Okay, perhaps we should start. I hope that you all hear me. Um, yeah, okay. So for those of you who don't know me, my name is Yehuda Neubauer. I'm the head of the legal practice at the Ehrlich Group, and I also had the trademark and design activity in the group. And we are gathered here today because many of our clients are repeatedly asking me whether there's any point in protecting their IP rights in China. People think that it's not very useful. There's not enough information about registration of IP rights in China, and people think it is impossible to enforce their IP rights in China. And to the contrary, I think that the answer is quite clear. It is extremely important to protect your right in China for various reasons: the size of the market, the enormous growth of the economy, and the fact that many infringements come from China is actually not a reason not to enforce your rights there. On the contrary, it is important to protect your rights there, and that would also help you to stop any infringement activity that is coming from China to other countries. But I think that the problems that people have with the enforcement of right in China is that the system in China is a little bit different than what we're used to in other countries, in Israel, in the United States, and in other countries. And since people don't really know how to tackle those differences, then they're sometimes reluctant from taking activity in China. And for that reason, I have here with me Mr. Asan Zhang and Mr. Michael Wu from Changti and Partners. Changti and Partners is a leading full-service Chinese law firm with a very strong reputation in intellectual property and litigation. We have heard some very good things about their prosecution and IP enforcement practice, and we started working with them, and we've been working with them in the past few years, and the cooperation is very successful. Um, as I said, Mr. Asan Zhang is with me. He provides consultation services in a wide range of intellectual properties in China, in both contentious and non-contentious matters. He specializes in the development of intellectual property strategy, enforcement programs, and I think he has some very interesting things to tell us today. Also with us is Mr. Wu, who's a senior patent attorney specialized in patent infringement cases and other matters related to patent application invalidation. He works in different fields, for example, in the mobile telecommunication industry, software patent litigation, and many more. So what we'll do today is that we will have a discussion, not a lecture. I hope that we will manage to keep it dynamic and more interesting that way. We will start by talking a little bit about protection of IP rights in the sense of filing IP rights in China, and then we'll discuss the enforcement of IP rights in China. If you have any questions, please send us write something on the chat, on the Q&A. You can also raise your hand, and we'll be happy to assist whenever possible. So without further ado, I suggest that we start our discussion. So let's start by discussing the different IP rights that could be filed in China. Asan, Michael, could you please tell us a little bit about the different rights that can be registered in China, and about special rights that can be filed in China?
Yeah.
Yeah.
Yeah. Hello. Hi. Thank you, Yehuda, and glad to see all of you. Regarding the question Yehuda just raised, there are various IP rights in China. Many includes patent, trademark, copyright. But for the patent, it can be further divided into three further types: invention, utility model, and a design patent. For our clients, if they would like to protect your IP rights in China, you'd better register these IP rights in China. For example, if you have a technology or some technology related related methods, you can file patent invention with the China authority. Also, if you have your brand, we can suggest you file trademark registration in China, as well as the situation for copyright.
So if we talk about patents, and many of our clients are very particularly interested in patents, based on my experience, I know that the term of a patent in China is 20 years from the filing date, right? Like most of the countries in the world.
Yes, yeah, 20 years.
What could be interesting for us, for our clients, is about those special patents. What's going on in China with respect to software patents or to business method patents? Are those registered in China?
Oh yeah, the answer to both of these questions are yes. Yeah, the software can be patentable in China. Yeah, all of us know that the source code of the software is not patentable. Yeah, the source code is not patentable, which is covered by copyright law. However, the method embodied in a software, a method, and such method can be used to handle technical problems, which means that this method is a technical solution. And then such technical solution is patentable, which means that the method is patentable. Okay, this is answer to your first question. And the second question is relating to the business model, business method. Yeah, we know that the business method, whether or not the business method is patentable, this is very controversial among different jurisdictions. I know that in the United States, yeah, the business method can be protected under patent law, has already been discussed in many years. In China, from just 3 years ago, from 2017, the Patent Office issued a very important guideline. Yeah, such guideline can be regarded as the green light for business method patent in China, which means that from 3 years ago, the business method is patentable, as long as the claim of such business method patent contain both the subject matter or business rules and the method and even the technical features. Please note, I just want to mention that everyone should notice that the technical features is very important. If in the claims of such a business method, if we cannot find any technical features, and such patent is very dangerous, and perhaps this will be rejected. But if you connect the technical features to the business rules, and under the new guideline of Patent Office, such business method will be patentable. Yeah, and meanwhile, I will share some rumors with all of you. That's a rumor, yeah. We know that such new guideline is from some Chinese giant e-commerce company, such as Tmall, Taobao, and JD. This company pushed more and more pressure on Chinese patent office. You know, they are similar to Amazon in United States. They are powerful and they are giant company. When they need such business method to be patentable, and they just want more protection under patent law, so they push more pressure on the patent office. At last, such a business method become patentable. Okay, that's a rumor. Okay.
So what I'm hearing from you is what you're saying is even though a client sees that his business method cannot be registered in other countries, in the United States or in Israel, he still has a chance to register a patent in China, as long as there are some technical features in the claims of the patents. So it is worthwhile. If China is an important market for you, then the fact that your patent attorney here in my office tells you you cannot protect your invention doesn't mean that you can't do it in China. And perhaps this is something that should be discussed further with a local Chinese agent.
Yeah, I mentioned that there will be a possibility, which means that the business method patent is not prohibited. Yeah, as long as you connection some technical feature to the claim, and such business rule with the technical feature can solve some technical problem. Yeah, the technical feature, technical problem, these are important. Yeah, without these technical features and technical problems, such claim might be deemed as pure mental activities. Pure mental activities is not patentable. I just think that in all of the country, such pure mental activities is not patentable. Yes. But we just want to push more technical feature into the claim.
I understand. What about the times that it takes to register a patent in China? How long does it take to register a patent from filing the patent to getting it?
Yeah, you mean the utility patent? Yeah,
that's about utility.
Yeah, usually takes around 3 to 5 years. 3 to 5 years. But during these days, we always suggest our clients through the PPH. PPH, yeah. With PPH, such a period can be decreased into 1.5 years. PPH is always be hastened.
For the benefit of our clients, can you please explain a little bit about this route?
Yeah.
So can you please explain what this shorter route is for those of us who do not understand?
You mean the shorter routes? Yeah. We always suggest our client use the PPH. PPH. Yeah, PPH is a choice when you're patent.
Just if there's anyone who doesn't know what a PPH is.
Okay. Yeah, you don't know PPH. Just wait a minute. Yeah. PPH is that in different local office, such as the United States, EU, Australia, Japan, Korea, and China. Yeah, when a patent is granted in some patent office, just like when the patent is granted in USPTA, and then we can file this patent to enter China, and use this which called a patent highway. It's a highway, highway. When our patent goes through the highway, and then it will usually take less time to register a patent in China. That is called a patent highway.
So it hasn't mentioned another type of patents that exist in China, and many people don't know about this type of patents because we don't have it in Israel, for instance, and that's the utility model. Could you tell us a little bit about utility models in particularly in China?
Yeah. Before I answer this question, after this meeting, we can share some further information about the PPH. Okay. And such explanation will make the audience more easy to understand. Okay, I will discuss what is the utility model. Yeah, the utility model only protect new technical solutions for the shape or structure of a product or the combination, which such shape, structure, or the combination are fit for a particular use. Yeah, which means that the subject matter of the utility model patent is limited to the improvement on the shape or the structure. And furthermore, I just want to mention that the method or the process of the method and process of a software cannot be registered as utility model. And even the pure material or medical improvement is not registered as utility model. Yeah, so which means that the subject matter of the utility model is narrower than the invention patent. Yeah, but the utility model has some different advantages. Yeah. Do you understand what is the utility model?
Yeah. Yes. If you can tell us about the advantages, that would be wonderful.
Yeah. The advantage of utility model patent is that such utility model patent is without substantial examination. Yeah, which means that we can get a utility model patent with maybe less than 1 year. Less than 1 year, we can get a utility model patent. Even our record for the quickest utility model patent is less than 8 months.
Wow.
Okay,
but it's not for it's for every field. It's not for every field.
Not for every field. Yeah, just according to our experience, 12 months is very common for a utility model patent. 12 months. And the another advantage is the low cost. It's kind of economic. Yeah, low cost. The cost for finding a utility model is less than the cost for invention patent. The cost is a little economic. Okay, the allowance rate for the utility model is about 37% of an invention patent. But yeah. I just remember that these are the advantage of utility model patent. On the other hand, we always suggest our client to use the dual filing, double filing, which means that, double filing. Yeah, so when we file an invention patent, at the same day, we can file another utility model patent. Yeah, as long as the subject matter of this invention patent can also be used as a utility model patent. Yeah, which means that if your invention patent is a method, so you cannot use the double filing. But if your invention patent is regarding to a shape or structure of a product, and then you can use the dual filing.
What
which
about
means that?
yeah? Sorry, I didn't mean to cut you.
Yeah, just go ahead. Sorry,
No,
just go
I
ahead.
was just curious what happens if it's a national phase of a PCT application. Then what can be done? Is it has to be either one of them?
Yes, yeah. In your national phase, you can also use such double filing.
Oh, you can use double filing. I see that I was a little bit negligent, and I see that there are some of our viewers that have asked some questions, and I wasn't careful, and I didn't notice in time. So I just want to ask you some of the questions that were raised here. And Rachel is asking us regarding business method patent, is it necessary that the technical features in the claim are novel, or is it enough that the method is novel, even if the actual technical features are not novel?
Oh, that's a great question. Yeah, yeah. But I just want to think that that's absolutely a case by case. Yeah, but the technical feature is necessary.
So
that's necessary.
But what I'm trying to understand is what she's asking is basically it has to be technical, but the novelty doesn't have necessarily be the technical aspect. It has to be technical in nature, but the novelty aspect could be in the business method itself, and not in the technical aspect, and not in the technical features.
Yeah, I just think that the combination of the business method and the technical feature, if such a combination is novel, we are more likely to get such a patent, such a business method patent granted. Yeah, but I just think that if the technical feature, I'm sorry. I just think that your question, is a case by case question.
I see.
Yeah.
And another question that we were asked is about a new option to delay the prosecution in China.
A delay of the patent. Yeah. The delay of the patent. We can when we file a patent in China, especially on the invention patent, we have 18 months to publicize this. And when we want to delay this patent, we can publicize this patent as late as such 18 months. Yeah, but I remember that some of my colleagues told me the method to delay the patent, especially on the medical and the chemistry field. Yeah, some of our clients also want to delay the patent application. After this meeting, I can share such information with you. Okay. How to delay a patent. Okay.
So we will share it with the person who asked us the question, and thank you very much for that.
Yes. Yes.
Okay, so let's get back to our discussion about the different rights, and we're going to design patents, which also exist. Oh, about utility model, we didn't say how what's the term of a utility model?
10 years.
10 years.
10 years. Yes.
Yeah. Okay, and so let's talk about design patents.
Okay.
What is the term of a design patent?
Now, just in these years, the term of the design is 10 years. But from the next June, in next June, the term for design will be 15 years. Because at that time, A new amendment for the patent law will come into effect. At that time, the term for a design will be 15 years.
I guess that most of our clients know that, but I'm just commenting that design patents are intended to protect the aesthetical appearance of a product as opposed to the technical aspects of those of a product. Is there a protection for unregistered designs in China?
No. No. Yeah, I have to say. Yeah, I want to say yes, but the fact is that no. Yeah, unregistered design cannot get a patent protection, but we can also help our client to protect under trade dress, or even copyright.
Yeah.
Yeah.
Okay, so if we're talking about copyrights, maybe we should say a few words about copyrights. Is it granted automatically in China? Is there anything that you have to record or register?
Yeah. Okay, I can answer. Yeah. Yeah. For this question, the answer is yes.
Waiting so long.
Yes, the answer is yes. Copyrightable work can be protected automatically once it is created, according to the copyright law of China.
So it's protectable. And about recordal and registration?
Generally, it is not necessary for the works to be recorded or to be registered for protection. According to the copyright law, this work is protected after it is created. The protection arises automatically. But generally in legal practice, we suggest our clients to register the copyrightable work because after the registration of the copyrightable work, we can get a certificate. On the certificate, it shows the owner and the public date and a creation date of the works. So that will clearly illustrate to others that we are the rightful owner of this work. So that ultimately will help our enforcement in China.
I see. And what about trademarks? Trademarks are trademarks. I know trademarks are trademarks everywhere, and usually the term is identical, 10 years. But I'd be happy if you could give us some tips regarding the phrasing of the lists of goods and services in China, because I have this feeling that when we draft those trademark applications, the rules are a little bit different in China.
Yeah.
So what is it? Why are we falling? Why are we failing to draft lists of goods that are adequate for China based on foreign registrations?
Yeah, this is a very good question because as you may noted from our previous cooperation, China adopts the unique subclass practice. Unlike other countries, China adopts this unique subclass. Each international class is further divided into different subclasses, and some subclasses are further divided to different parts under the Chinese local practice. So the goods in different subclasses of the same class will be deemed as dissimilar. So do the goods in different parts of some subclasses. So the key word is subclass. For example, even though both clothing and shoes fall in international class 25, since they fall in different subclasses, the similar trademark can coexist on clothing and shoes in China. Uh, this sounds a little bit strange, but this is really the situation in China. So if you apply a trademark on clothing, uh, others can also apply the same trademark on shoes, because in China, clothing and shoes are divided into different subclass under class 25. So they can coexist and they are dissimilar under China local practice. So we generally advise our client to file trademark application to cover all subclasses in each class to obtain the broadest protection.
Do you have to pay additional fees for an additional subclass, or it is all included in the same class and only one fee per class?
Yeah, we generally suggest uh, uh, select one from every subclasses to have a defensive protection. But for the key products of the clients, we generally choose them according to the China subclass practice.
So I have a question, which is I don't know. We many of our clients are facing the same scenarios in which they get an email from a Chinese law firm or a Chinese person telling them, please be aware, someone registered your company name, your trademark in China, sometimes for the same products that the client used, sometimes for other products. And sometimes the client is not really active in China yet. He plans to do it, but sometimes he's starting, sometimes he has no intention. But they are all debating what to do. So can you give us some, I don't know, some guidance as what should we do when we see those emails? Should we read them? Should we ignore them? What should we do?
Yeah, yeah. In fact, that happens a lot in our practice. For such kind of email, you can see that many of them is just a scam or solicitation. And the Chinese individuals who send the emails want to trick the client doing business with them. So please forward, generally we suggest our clients that please forward the email to our firm, and we can help the client to handle this kind of email. We generally do some online research into the email sender and the trademarks they mentioned. Generally, based on our research, we can advise the client how to do for the next step. Most of the situations that we can ignore the email because it is kind of solicitation or scam. But if the client want to have an audit under the context of the email, we can conduct some analysis and provide advice regarding new filing or regarding possible actions against the pirated trademark filed by some third parties. Uh, this is a general situation.
I see that there's that again that we have an interesting an important question here about trademarks, and this is the significance of Chinese name translation. Whether it is really necessary to translate a Latin name to Chinese and file a trademark application for that, or is it just advisable?
Yeah, that's very important because in China, Chinese people recognize brands using Chinese word. For example, when they refer to Coca-Cola, they do not say, I want to drink a Coca-Cola. They generally say, I want to drink Coca-Cola. And also for BMW, if they want to buy a car, a BMW branded car, they do not say, I want to buy a BMW. They just say, I want to buy 宝马 car. So in under the Chinese culture and the Chinese market, proper and acceptable Chinese name for your brand is very necessary in China. If you do not have a Chinese name for your brand, Chinese customers will give you a name. But if you do not apply the recognized Chinese name with the China authority, maybe some other copycat can apply them at the first place, because as you know that China is a country of first file principle country for trademark. So first of all, Chinese trademark is very important for Chinese to recognize your brand. And it is very important for you to apply the recognized Chinese name as your trademark in China as early as possible.
So you actually answered my next question to you. So it is important, since it's a first to file system, it is important to register trademarks as early as possible. The fact that you started using the trademark in China is not sufficient to protect your trademark if someone else filed first. And also, I understand that it's very important to protect the Chinese version of the mark.
Yeah.
Yes. So maybe we should start talking a little bit about enforcement of IP rights in China, and I think that that's something that is very, very important for our clients. And because what I said, there's this what I think is a misconception that actually it's very hard to get IP enforcement in China. And I'll ask you a preliminary question, which is maybe not very politically correct, but do you think that foreign entities, foreign IP owners, IP rights owners are less likely to get a remedy in China?
Yes, that's a good question. I would like to see that the situation is becoming much better now for foreigners or foreign clients, because as you see, we represent lots of foreign clients in China, and we do not feel that clients are treated differently by China authority, courts or custom officials. Most of our claim in some actions are supported by these authorities, especially in these recent years of U.S.-China trade war. Under the pressure of the trade war, China revised its IP law more frequently, such as we have revision to our patent law, trademark law, and copyright law, as well as our anti-unfair competition law. We revised this law to become more friendly to foreign clients. Not only from the legislation perspective, we revised law in legal practice. The judicial departments also become more active to the protection of foreigners' IPs. This above introduction is just about the overall environment in China, but some local protectionism is still existing in certain undeveloped areas. So we generally suggest our clients to file our actions in some developed areas in China, because in that developed areas, the authority is more open-minded, and they are more aligned with China central government's mind to protect foreigners' IP under the trade war pressure, as well. Also, the developed area in the developed areas, the judges of IP cases are more experienced, and we generally suggest we choose carefully about the volume of the first cases. This is a jurisdiction issue. We can further discuss further in specific cases.
I see. So you in China also have your Texas, where you should go to enforce your patents or other rights. It is important where you go.
Yeah, it is very important.
The venue. That's very interesting. So, okay, so let's talk a little bit about enforcement. And I think that one very interesting thing is what is called border protection. And I understand that there are ways to stop infringing products from getting into China and leaving China by ways of reporting your IP rights at the customs. Can you please tell us about it? What type of rights can be reported at the customs? How does it work?
Generally, there's no limitation to the type of rights to be recorded at the customs. For example, trademark, copyright, and patent can all be recorded at the custom. However, the trademark is much preferred by the customer, because, as you see, trademark can be searched and can be seen very easily in the customs daily inspection. Yeah, that's the situation.
So I understand that it's easier for the customs to stop infringing activities, but many of our clients are facing issues with patent infringement that comes from China. The question is what do the customs authorities do when you have recorded your patent at the customs? How can they stop the goods? Do you need to give them some notice in advance, provide them with details? How does it work with respect to patents?
Yeah.
The yeah, I think your question is related to the border protections procedure. Is that right?
Yes. What is done with respect to patents?
Yeah, yeah. First of all, we need to open an account for the client in the custom IPR system. It is an online system for the client to register their patent rights and authorize the users. Uh, this is first. Second, we can then register our client's patent as well as other IP rights into the system under this account. Third, if the client has some authorized users which will export the goods incorporating the client's patent rights, we can register these authorized users under these patent rights, so that the exportation will not be delayed by the custom. Fourth, if there is some suspected infringers who export their products incorporating our client's patent right, the custom officials will have a check to see if the exporter is an authorized user. If the exporter is not an authorized user, the custom will temporarily detain the goods and send the client and us notification. Generally, they send the notification to us. For example, if we are the agent of the client, the notification will request us to identify whether the goods are authorized or not. We are required to file a formal reply to the customer on whether to seize or release the goods within 3 working days. So in that situation, we have a chance to have a check into the goods to see whether they infringe upon the client's patent. If yes, we can file a seizure application with the custom, and the custom will seize the goods and start an administrative investigation. After the investigation, normally the custom will hold that the goods infringe upon our client's patent right. They will issue a punishment decision to confiscate the infringing goods and impose a fine on the exporter. The confiscated goods will be destroyed later. That's the whole procedure for border protection.
And do you have can you train the people there about the patent rights or other rights that the client has? I guess, yeah.
Yeah, generally in China, custom ports will organize some training session. Through this training session, the officials of the inspection department will invite some patent owner or trademark owners to attend the training. In that training, the owner themselves or the agent of the owner of the patent will give some training to the officials of inspection. So in this way, that will help the custom officials to learn our IP rights, our patents. After that, they will have much more knowledge about the patents, and they will seize the suspected exporters more efficient.
And is it expensive, this whole recording thing and this training? Is it something expensive for a client?
And that's not expensive. The training is very important, but that's not expensive.
The whole process is not. I mean, the recordal itself is also not very expensive, right?
Not expensive. It is a very cost-effective way to stop infringement on the border. Compared, this is just a comparison. They compared with investigation, redaction, or litigation within China.
So we'll talk about those options as well. What you're saying is basically, if you have an IP right in China, if you think that you're being infringed or you're about to be infringed, go ahead, record your IP rights at the customs, and that will give you tools to detain, to stop those infringing goods, and perhaps even confiscate and destroy them.
Yeah. Yes.
Okay, so moving forward, you mentioned the other options, and these are things that I think that for us foreigners, for us Israelis, or from other nationalities, it's sometimes hard to understand the different type of tools that you have in terms of enforcement. We usually send cease and desist letters, and then we go to court. But in China, I know that there's a very high importance of investigating, do some evidence preservation, and there are some raid actions. These are creatures that we're not familiar with, and I'll be grateful if you could tell us a little bit about those issues.
Yeah. Generally, for IP enforcement or litigation, the first step is investigation. This is a field investigation. After the investigation, we learned a lot about the infringement and the infringer, and then we proceed to conduct the authorization to preserve the infringement. After the evidence preserved, we will then send a CD letter, cease and desist letter to the infringers to see whether they are cooperative. If they are not cooperative, we will file the civil litigation. So without an investigation, we cannot know the nature of the infringement, whether it is a trademark infringement, whether it is an unfair competition or design patent infringement. We through the investigation, we can know the nature of the infringement as well as the true identity of the infringer. Because in China, if we want to file a civil litigation, we shall make sure the true identity of the infringer. In China, there are many fake company. So the investigation is very important in China. The investigation will reveal lots of information which can help us to determine the next steps and our overall strategy against an infringer. For instance, from an investigation, we can determine one, whether the target is conducting infringement. Two, what is the nature of the infringement. Three, whether the target is very large or whether the target is a competitor of the client. Four, for example, whether the infringement is very severe, and whether there is a very big stock or inventory of the counterfeits on site. From the information revealed by the investigation, we can form our strategy, such as filing a read action. For this read action, we mean that if we find some inventory or stock at the target's store or the target's warehouse, we can report this situation to the local authority, and the local authority can file a read action against target to seize the counterfeit on site. If we cannot find the stock or inventories at site through our investigation, our strategy for next steps may be sending a cease and desist letter or initiating a legal action. So field investigation is normally a good start in our potential infringement case, unless the client has gathered enough information concerning the infringement or the target. This is about the investigation. Evidence preservation. Evidence preservation is usually following the investigation. The evidence shall be notarized under the witness of notaries. Because litigation cases before courts in China requires evidence to be notarized. This is a requirement in China. Otherwise, the evidence is not adequate to support our claim before courts. From our experience, in several cases, some clients did not preserve the evidence and directly sending cease and desist letter to the client, to the target, the infringer. After receipt of the cease and desist letter, the target get alert by our letters and moved their infringing activities underground. So when we would like to take a litigation against the target denied that they had conducted infringement, and we could not prevent the evidence at that point because the target has removed their infringement from our side. We cannot conduct the evidence preservation so smoothly.
I think as we also in our cases in our jurisdiction we also gather evidence before we send cease and desist letters. But I think that one thing that is sometimes hard for us to understand, or for our clients to understand, is the importance of the notarization process of the evidence. Can you use the evidence without notarizing it?
Generally, Chinese court require the infringement evidence be notarized because in IP cases in China, if we do not notarize the infringement evidence, some information can be revised, altered by the infringers. So the courts require that we preserve the evidence through notarization. For example, there is a trademark. A trademark, if a trademark is posted on the official website of the infringer, if we do not notarize the website through notarization, in our litigation, the defendant may remove or delete the trademark from their official website. So if in that case, our evidence are not notarized, the probative force becomes much lower. So that's the reason why the courts require the evidence notarized, because notarized evidence is more reliable under China practice.
儒权我加一句好吧？
Okay, Michael, you can go ahead.
Yeah. From the patent litigation side, I just want to share some points with all of you. Okay. Yeah, there's no discovery in China. Yeah, there's no discovery, which means that we cannot file request to request the defendant to provide some evidence. Yeah, which means that as the plaintiff, as the patentee, we have to collect infringement evidence by ourselves. And under such circumstance, we have to conduct the evidence notarization. Yeah, through such notarization, we can collect the concrete evidence, and such evidence will not be modified or will not be changed. If without such evidence notarization, and then we send a CD letter to the suspected infringer, and the infringer is more likely to conduct the design around, yeah, because in our CD letter, we might attach some claim chart. Yeah, we will compare our patent to the infringing products, because we just want to prove that there exists patent infringement. Okay, when they receive such a CD letter, the infringer will know our patent, and they will know the claim chart, and they are more likely to conduct the design around. At that time, when we file the litigation, and the defendant might take out some new product. Yeah, at that time we are very awkward, and it's hostile to the plaintiff. So we always recommend our client to conduct the evidence notarization, because the evidence is preserved. Okay.
That's very interesting and useful. I have to say that our time is running out. I've seen a lot of interesting questions that were sent to us, and obviously we couldn't address them during this conversation. But what we'll do is that we will approach those people, and we'll get back to Michael and ask them to provide you with this information. We have some questions about pharmaceuticals, about plant breeder rights, about grace periods in China, and perhaps we'll send you answers privately. Just before we leave, just a quick note about raids and litigation. Just a few words. I'm sorry that we're running out of time. Asen, Michael, anything about raids?
Yeah, you mentioned the read action.
Yeah.
Read action. Yeah, we can
Ethan.
give you a brief introduction. Read action means that if we find the counterfeit products on the target sites, such as at the target store or in the warehouse of the target, we can report this finding to the local authority. And the local authority means that the local market supervision administration or the local public security bureau. After our complaint to the local authority will initiate some inspection to the target sites, such as to the target's warehouse. If the counterfeit still exists there, the officials, local authorities will seize all the counterfeits on site and maybe take some criminal actions against the owner of the warehouse or the store. So this action is very forceful and very time efficient. Because these actions do not require the client to preserve evidence. They just require the client to provide the true finding. If we truly find the counterfeits at a certain address, we can report our finding to the local authority. That's very time effective and cost effective compared with the litigation. After the read action against the warehouse, the local authority will issue a punishment decision against the owner of the warehouse. And if the amount or the counterfeits meet the threshold of the criminal law, the owner will be charged with criminal crime action. That's about the read action.
Yeah. So I look at the watch and I want to I have so many questions to you, but it's very important. It was very interesting and useful. I think that we all learned that there are a lot of enforcement of possibilities in China, and there are a lot of nuances that we haven't addressed. Um, thank you very much for your time. And to all our clients, we will try to answer your questions, provide you some more information with the assistance of Asin and Michael here. And maybe we'll have another discussion to dig into some more detailed tips about filing and enforcement of rights. If any of you have any additional questions that you didn't raise today, or if you have any questions or interest in protecting yourself or enforcing your right in China, we're here to assist, Aston and Michael also. So just feel free to approach us. Thank you for your time, everyone.
Thank you.
Thank you. Thanks for all of you. Thank you for your time.